Good evening, everyone. We will wait for 5 minutes so that other participants also join. Good evening, everyone. A very warm welcome to all the participants joining us today. I am Payal Jangra, Operating Officer of VIDHIGYATA, and I am delighted to host this webinar on the occasion of Constitution Day. So, before we begin, I would like to announce a very important announcement, that is, e-certificates will be issued only to those participants who mention their name in the chat box during the session. So kindly make sure to write your name once in the call message. So, Constitution Day reminds us of the incredible vision of our framers who shaped our Indian Constitution that protects our liberty, equality, dignity, and justice for every individual. Today's webinar focuses on a theme that lies at the heart of modern constitutional discourse: evolution of fundamental rights and the relevance of data protection and privacy in modern India, issues and challenges. As India moves deeper into the digital age, question of privacy, surveillance, data protection, and individual autonomy have become more critical than ever. This session aims to explore how fundamental rights have evolved and how privacy is now an essential pillar of our constitutional democracy. It is my honor to introduce our esteemed speaker for the evening, Dr. Shasya Mishra, Assistant Professor and Domain Expert in Cyber Law, School of Legal Studies, Uttar Pradesh State Institute of Forensic Science, Lucknow. Dr. Mishra is a graduate of DAV PG College, Lucknow, and a postgraduate from Baba Saheb Bhimrao Ambedkar University. She has qualified the National Eligibility Test NET. Her research work focuses on cyber crimes against women, and she holds academic expertise in international human rights law, constitutional law, and jurisprudence. She has served as faculty at MIT Law School, Lucknow, and Baba Saheb Bhimrao Ambedkar University, Lucknow, and has been actively involved in several major seminars on privacy, data protection, and human rights issues. With over 10 years of university teaching experience, several publications, book chapters, and her book, Cybercrime Against Women in India, Dr. Mishra has contributed significantly to contemporary constitutional and cyber law discourse. We are truly honored to have her with us today. With great respect, I now invite Dr. Mishra to begin the session. Ma'am, the session is now over to you.
Good evening, everyone. Am I audible?
Yes, ma'am. Good
Yes,
evening.
ma'am.
Yes, ma'am, you are
Ma'am.
audible.
Good evening, ma'am.
Okay. So, okay. So, thank you so much, Payal, for this introduction. And then I want to thank this VIDHIGYATA portal for giving me an opportunity for sharing my thoughts on this auspicious occasion of the Constitution Day. Now, as we know that we are in the 76th year of the after the making of our Constitution, we know that our Constitution is a document in legal sense, as well as this is one of the document that is being created for the social transformation. With the passage of time, there were several changes, amendments that have been done in the Constitution. So today, my area of delivering my thoughts will be the role of fundamental rights, or how the fundamental rights are being evolved under the constitution, and then how right to privacy, which was earlier just limited to the physical privacy, has now switched its arena from physical to the virtual world. So the one thing which now this entire lecture is this entire session is all about the evolution of the fundamental right, as well as what is the present scenario related to right to privacy. So organizer, if you give me the permission, I can share my screen. Am I audible?
Yes, ma'am.
Yes, Manas, please allow me to share my screen.
Yeah, yes, ma'am. Just a second. Ma'am, please upload the.
Yes, yes, yes. Is it visible?
Yes, ma'am.
Okay, just give me a minute. Now it's visible. So, without wasting much of the time, I'll start with the topic, that is the evolution of fundamental right, and how the what is the relevance of the fundamental right in the present scenario with the changing dimensions of right to privacy. Now, as I've already said, that fundamental rights are the rights that were basically related to the not only this is something not only just mentioned in the constitution just for the sake of the rights, but this is one of the things that actually transformed, that has entirely changed our country. Now, starting with the introduction, as we know that Constitution is the law of the land, it is a legal document. It is our Constitution, which is the lengthiest document that has been created, or the largest written Constitution, which it took 2 years, and 11 sessions were conducted, and there is a long process, long struggle when the Constitution was in the making. So it is a kind of a living organism, which we can say, and. Why I'm saying this is it is a living organism, because living organism, who is a living organism, which is someone who can breathe, someone who can mold itself, someone who can transform itself, someone who can change itself. So the constitution of a country, we can say, it is a living document. It is a kind of a living organism which transform itself as per the need of the society. And as I mentioned, there were 299 members that were continuously working for in the making of the constitution. That is the scenario post partition. Before the partition, there were more than 300 people that were engaged in the making of the constitution, and after the your partition, 299 members were there, in which 15 were females, and rest of the members who had entirely worked for the making of the different parts of the constitution. Now, as we can see, I have initiated with how the constituent assembly was made. So in 1946, this is a brief overview. Initially, I have given a brief journey that how the fundamental rights have been included in our constitution, and later on how right to privacy has been included. So as you can see that in 1946, the cabinet mission plan came, and I will tell you the relevance of this cabinet mission plan in my later on slides. And what happened that the first session of the Constituent Assembly was conducted on December 9, 1946, under the chairmanship of Dr. Rajendra Prasad. And in 1946, that is on December 1946, Pandit Jawaharlal Nehru came up with the objective resolution, which you can say it is a kind of the constitution for our country, where they have mainly discussed, as it is mentioned, that it is a philosophical foundation for our constitution. So you can understand the vitality or the importance of this document, that is the objective resolution. And in this document they have mentioned that what are the core areas, core interest areas, what are the core rights which must be available to the citizen of our country. Now, these are the important events basically which took place in the inclusion of fundamental rights in the making of the constitution. First one is the Nehru report, and then the Karachi resolution and the Sapru report, which we will discuss later on. So, the Nehru report is a kind of a declaration of rights, which basically says that, as we know, that India was under the regime of the Britishers for around 200 years. That was a large, long time, very long time. And the first thing, why the fundamental rights were included earlier, and then the directive principles of a state policy. So the thing is that, as we know, that we were under the regime of the regime of the Britishers. They have suppressed our rights. They have not given us the opportunity as an Indian to live freely. Now, live freely here means with certain basic freedoms, with certain basic human rights. So, what happened here? That a Nehru report, which is a declaration of rights, and whose rights? That is the rights of the minority, that is the rights of the people who are not being properly represented, that is the right of the downtrodden people. And with that, it also mentioned that why we need these rights. The concern was shown on the rights of the minority, reason being again, as our country went to the phase of the partition. And you can understand that what was the concern at that moment. And therefore and it is not something which has happened in one day or one night, because India was very diverse from the very initial phase. So you can understand what happened in 1928 when the Nehru report came. It also focuses on the rights of the minority. And post partition, again, when the discussions took place, the committee was being formed for the rights of the minority. So, as it was the time of 1928, because we have a very diverse population, minority, who will be considered as minority? Someone who is having less population. So, less than 50%. So, here the criteria or the rights of the minorities were discussed, and it has been said that this is a declaration of rights where we have to see the minority right. We have to give importance to the rights of minority also. Now, this document was presented, and the entire discussions took place in Lucknow. That was in the year 1928. Now, the Karachi resolution. The next we came up with the Karachi resolution that came in the year 1931. And this is again a revolutionary document. I'll tell you how it is a revolutionary document in the later on slide. But for you people, you just understand this thing, that from this document, the concern regarding certain basic freedoms were given, or it has been discussed. And it has opened avenue towards the directive principles of state policy also. So here, as I'm discussing about the FR, I'm discussing about the fundamental rights mainly. But this Karachi resolution basically tells that what should be the duty of the state. What are the criteria? What is the importance of social justice in the society, and how the state should perform its function in order to provide social justice. After that, these were the members of drafting committee. So these were the members. Dr. Ambedkar was the chairperson, and the other members, they have discussed about the drafts of the constitution. Those who played the major role. Now, this is the entire chronology when the drafting committee was constituted, when was the first draft was issued, how many articles were there. So initially there were 315 articles, 18 parts, and 8 schedules. Now this draft was revised on 4th November 1948. And the later on debate was being done regarding the entire revision of the draft, and this was a major phase, that is from November 15th 1948 to October 17th 1949, where debate on different articles were being of the constitution was being conducted, and then later on the second draft was introduced, and finally on 26th of November 1949 we have adopted our constitution. Now, what is the importance of fundamental right? So, those who are from the law background, or those who are even not from the law background, I have made the slides very understanding, very simple, so that everyone can understand that what are the basic ideas or basic fundamental philosophy behind every portion of the constitution that I'm going to discuss today. So, fundamental rights, what? These are the constitutionally granted freedom. These are the rights which are justiciable and enforceable, which means you can enforce these rights in the court of law. These are the certain basic freedoms, and why these fundamental rights are given under our constitution, so that there should not be any kind of arbitrary action of the government. These were the rights that were related to dignity, liberty, and equality of an individual, and they are not absolute in nature. Now, going through every constitutional assembly debate in context to the fundamental right, this is one of the major area that was discussed again and again, that whether we should provide fundamental rights in absolute sense, or we should create, or we should restrain these fundamental rights. So when I'll discuss the part of article 19, article 21, I'll just let you know that what was the discussion that took place in the constituent assembly, and what was the views of the makers of our constitution. And in various judgments also it has been said that fundamental rights are the rights which are important for the overall development of the individual. So you can understand the importance of FR. And as the topic is related to the evolution, so at the international, like if we talk about evolution, so in the Indian context we have dharmas, we have scriptures which talked about basic freedoms, that what is right and what is wrong, what is the role of the state and what is the role, or what is the work of the citizen. And when we talk about this fundamental right in the international scenario or from the jurisprudential point of view, we have to see the theories that were given by different scholars, like the modern natural law philosophers, mainly by Rawls, mainly by, you can say, the theory of Hobbes. And what was these theory basically? These theory basically says that if there are certain basic freedom, then given to the individual, given to the citizen, but those basic freedoms must have certain restrictions. And that is sorry, that is something which we understand. What is it? It is constitutionalism. And the concept of constitutionalism is something which is inherent in our constitution when we talk about the different powers, different functions, especially the part third of the constitution, that is the fundamental right. Now, what is constitutionalism? That is restricted governance, which means even if the king has been given the power, even if the state has been given the power, but the state cannot take any arbitrary action. And we know that how, like from 1215, the first document which came, which related to the basic human freedom, that is the Magna Carta, and then there was Bill of Right, and there were several other documents. So I'm not going in detail about that international scenario, but here on the Constitution Day, I'm just focusing on the Indian scenario, that how India has evolved its constitution, and how it has included fundamental rights in its document. So as you can see, that is key. Article 12 to 35 basically mentions the portion of fundamental right, that is the part third of the constitution. And now next we come to the evolution of fundamental rights. So in 1895, the first draft came into existence, and this draft was created by Lokmanya Bal Gangadhar Tilak. and this is known as the Swaraj Bill. Now, you can understand that what is the meaning of the term Swaraj? That is the self governance. So, what was the demand? That Indians want self governance, and in this document, we have mentioned about the civil liberties, freedom of speech, press, equality before law, and several other things. And we have discussed about the representatives that are being elected by the people, by the citizen, and restrictions on the colonial rules. After that, the second important event which took place in the making of the, or on the inclusion of the fundamental rights in the constitution, or uh, making of the constituent assembly, that is the Simon Commission. Now everyone know the slogan that Simon go back. Now what, why there was a demand that Simon should go back? Because Simon was making like, this was something related to the representation of the Indians, this was something related to the progress of the Indians. And for reviewing the Government of India Act 1919, after 10 years, the British appointed this commissions, that to 2 years earlier. Okay, so that that basically it should be constituted in 1929, but Britishers have constituted it in 1927. For what? For reason being that they want to create, they want to just go with their monopoly, and they are not willing to give any kind of benefit to the Indians. Now, what happened after this Simon Commission? Now, Simon Commission is a turning point in the history of the India, in the making of our Constituent Assembly. And after this, the Lahore incident took place, and Lahore incident resulted massive protest where Lajpat Rai was being injured, and later on he died also. So this is again one of the incidents where we were asking about our own rights. We were asking about our own document. We are asking about our own legal document. And after this, the Nehru report, which I have discussed earlier also, which basically talks about the bicameral legislature, responsible government, secular state, and protection of minorities. And now I'm telling you that why this Karachi resolution was important, because this Karachi resolution of 1931 discussed about freedom of speech and protection of civil liberties. I am going to emphasize, and you people are going to listen about the privacy. Privacy, not only in the physical sense, but it is in the virtual sense. And cyberspace is one of the place where the freedom of speech has been given to everyone. So, this Karachi resolution discussed or mentioned about the freedom of speech and equality as one of the integral part of our fundamental right, and later on it emphasizes upon the portion of DPSP also, that is the directive principle of state policy also. And here, as I mentioned some example like right to work, protection of labors, or you can say this is the document which basically outlined the framework, or it has provided certain blueprint that what actually our India wants, what actually our country wants, what actually we need as a citizen of our country. And it is one of the document which majorly discuss the socio-economic policies of the government. Now, when I'm saying the socio-economic policy, which means the document emphasizes on the uh, portion of inequality, that is how to minimize inequality and how to create an environment where the monetary benefits will also be given to every citizen without any kind of discrimination. So this document somewhere we can say work on the socialistic pattern of the society. And this socialistic pattern of the society, what do you understand? This socialistic pattern basically means the distribution on the basis of wealth, on the basis of opportunities. And here we can say that distribution of resources also. So, what was the core ideology behind this Karachi resolution? That is, somehow the certain civil liberties must be provided to the Indians, and there should be protection for such civil liberties. That is, if certain rights have been provided, which we used to say as a fundamental rights, so that should be protected, which means that the state must not unnecessarily, arbitrarily interfere in those rights. Okay, and the next point which says that it talks about the economic growth programs like the right to work, freedom of labors. Now we can see this portion also very easily in the directive principles of a state policy, which we say as the fundamental, like what when we use, like when we say that what is the importance of DPSP, then the directive principles of a state policy are something which are fundamental in the governance of the country. And we know the chronology that where on one hand the government, like the court said that the DPSP and FR are not equal to each other. Then they said that more importance must be given to the fundamental rights. And ultimately, it has been said that FR, that is the fundamental rights and directive principles of state policy, are complementary and supplementary to each other. Which, why? Because when we start with this chapter of fundamental right, it basically says what, that these are the rights which are fundamental in the governance of the country. And later on judiciary also mentioned this portion that when the law has to be made, when the legislature has been going to make the law, then equal importance must be given to the directive principles of state policy also. Now, what happened in the era of 42 to 45, this was the phase of world war. And that was a time also when the Britishers were losing their power up to certain extent. And in 1942 there was a Cripps mission, and there we there was the concern, there was the issue, there was a contention, there was a, you can say, discussion regarding the dominion status to India. And we Indians demanded, like we obviously demanded for the Swaraj thing, we obviously demanded for the Pur Swaraj also later on. And here also we want that Crisp mission basically emphasize, okay fine, we are going to, like, Indian representation must be there up to certain extent, that should not be also absolute. And from here the path has been opened, the avenue has been opened for the making of our own constituent assembly, and the avenue for the making of our constitution. So here you can see this thing, the importance of Cripps mission also. And then later on there was a Quit India movement also. There's a slogan that is do or die, that where we demanded for complete independence, or we can say we demanded for complete Swaraj. And 1946, this is again one of the most important event in the history of the making of our Constituent Assembly. That is the transfer of power. So as I have told you that after the Second World War, actually the Britishers, actually up to certain extent, they were losing their power, they were losing their command. And the result was that in 46 they actually transferred the power to the Indians so that they can make their own constitution, or they can make a constituent assembly which can work for the drafting of the constitution. So in 1946, basically certain elections were conducted regarding the constituent assembly thing. And on 9th December 1946, the first meeting of the constituent assembly was conducted. And rest on is the history, where the constituent assembly makers, the framers of our constitution, have drafted a beautiful document which they have included each and every aspect related to the need of the society. So 22 different committees were constituted, like the advisory committee related to fundamental rights, minority rights, tribal areas, and subcommittees were also being created. The names of the members who were the heads of the committee has been mentioned here. So for these committees, like as we talk about the fundamental right committee, so it basically worked under uh, the Lajpat Rai, and he was also focusing on these some of the committees, especially on the fundamental rights committee. And we know the role of this sorry, Sardar Vallabhbhai Patel. Sardar Vallabhbhai Patel basically worked for the this Fundamental Right Committee. As he, you know, the work of Sardar Vallabhbhai Patel, he is known as the Iron Man of India, where he was in the favor of the merging of these states. So the merging of the state, you know that then only we have this diverse population, we have this diverse people. So he actually played a very important role in the inclusion of various fundamental rights in our constitution. And the rest of the committees also, as it is mentioned, that is the rights of the minorities, that is the rights of the tribal area, that is the excluded and the partially excluded areas, where he has given his vision regard to the inclusion of these rights of the people who are living there. Now, these were the members which basically worked for the making of these fundamental right, and they have drafted it. And then we can see how, why, what is the aim of the inclusion of this fundamental right. So, as I have already told you that we were under the regime of the Britishers, and what they actually did, that is they suppressed our rights. And by suppressing the rights, they obviously created their monopoly in our country. They created a colonial government. And one of the main aim of these fundamental rights, now this is not something which has been just mentioned as random, but this was the core area of discussion also. That is why we need fundamental rights. So it has been given that we need the protection for my tribal, we need the protection for minority, we have to focus on the social economic rights, we have to work on the rights of the downtrodden people. And with that, we have to create an egalitarian society, and that society must have all the basic freedoms. So what was the discussion by the members? That is, there should be harmony between individual liberty and the security of the state. Now this is a very important portion related to this particular session, where we are going to discuss about the freedom of speech and expression, and with that, why the privacy is important. Like, uh, the Constituent Assembly also focused on that, this core area. So now we can understand that how foresighted were the constitution makers, and they want to include fundamental rights, and at the same time they want to create a balance between the liberty and the security of the state. That is, if I give an example, we have Article 19 of the Constitution, which provide for the freedom of speech and expression. But that freedom of speech and expression is not absolute in its sense. It has certain restriction. And one of the first restriction is, that is the security of the state. That is something which is defamatory, that is something which is obscene, that is something which is going to affect the sovereignty of the state, that is something which is going to affect the friendly relations among the state. So this was the foresighted approach of our constitution maker, where they want to include the fundamental right, but at the same time they are not going to compromise with the security of the state. And that was the main reason where, when we can say, or as we can say, that the fundamental rights are not absolute in its sense. That is, if we are providing you with the fundamental right, it is basically, we are not going to give you the absolute freedom to do whatever you want to do, but as the law requires, or as the security of the state is concerned, you have to, yes, you have fundamental right, but you are not going beyond to the security of the state. So this was the main aim. And here, as you can see, that what was the approach of Pandit Jawaharlal Nehru. And he said that the passion, like, these were the commitments, these were the commitment, the efforts are the fundamental rights are the commitments. And the people of the India, the masses, have to, like, they have to fulfill, or the Constituent Assembly members, they have to fulfill the passion, or you have to fulfill the criteria of the Indian people. And that is something, you can say, we can easily see in our constitution when the power to make the constituent assembly has been transferred to our country. Constituent assembly didn't mention that we, the constituent assembly, is going to make this constitution in the preamble, or we, the people of constituent assembly, are going to make the constitution. What we have mentioned in the preamble, we said we, the people of India. So the people of India are actually the sovereign people, and the document has been made for we, the people of India, where certain freedoms are being given to them, certain rights are being given to them, certain uh, provisions are been given, certain articles have been given, which article basically provide them certain human rights. So this is again a very interesting approach in the sense that we used to say that FR are something which are human rights. So human rights are something which are available since birth. Human rights are something that are something which cannot be transferred. So human right are something which is something, uh, this is something which we can get at the time we take a birth. So here the fundamental right, the makers of the constitution also emphasize on this portion of human right approach also. Reason being, this is like those who are from the law background, or those who are pursuing their law or doing preparation. Now, this is something where we are used to say that every human right cannot be a fundamental right, but every fundamental right is a human right. Why it has been said? Because the fundamental rights are the basic freedom, and these basic freedoms are nothing more than the human right, and human right are something which are available since existence. So for these human rights, we can say we have included these fundamental rights so that we have assurance against the basic human rights, against whom? Against the state. And a state cannot invade our basic human rights. And therefore, when you read the Constitution, Article 12 basically mentions the state. That is, against whom the FRs are, fundamental rights are available. It is available against the state. And under that state, they have mentioned about the local authorities and the other authorities. So Article 12 basically set a platform. Yes, from now onwards, we are going to discuss the fundamental rights. But against whom these fundamental rights have been given? The fundamental rights are given under against the state. So now this is the entire evolution. So I have mentioned in the international scenario also how we have included the fundamental rights in our constitution. So the makers of the constitution, they basically took references from the constitution of USA, Ireland, and the international treaties, where the universal declaration on human rights that came in the year 1948, and it was also in the making, it was also been made. And we took references from this international treaty, where the two generations of human rights have been given. The UDHR is one of the document where in one single document the two generations of human rights have been given. That is the civil and political rights and the economic, social and cultural rights. And when we see our constitution, FR, that is the portion of fundamental right, is something which is a socio-economic right. We can say these are the rights which are for the socio-economic justice. So the importance or the relevance, or you can say the uh, help which we have taken from this Universal Declaration of Human Rights is basically we can see in our constitution, because whatever human rights have been given there, we have tried to incorporate that as a part of fundamental rights in our constitution. Similarly, when we talk about the constitution of USA, yes, we have taken 14, we have taken like 14, article 14 of the constitution. Likewise, we have included this earlier, like right to property is also been given under our constitution, but right to property has been removed. There was a long history behind it, and right to property is given under the constitution of USA also. So we have taken help from the constitution of different countries, and by this thorough discussion, the next challenge which came in front of the Constituent Assembly, that whether to make these fundamental rights are justiciable rights or the non-justiciable rights. And it has been said ultimately that is, we are going to make these rights as justiciable right. And then there were discussions regarding the separate electrode, that is the election commission which used to read now. So that was something which was suggested by the Pokar Bahadur, and then later on it was being criticized by Sardar Patel, and that was something he said that it is going to affect our political, or we can, it is going to affect the democratic nature of our country. So that was the view of Sardar Patel. Now, the other debate regarding the inclusion of fundamental right in our constitution, that is regarding the scope of fundamental right, that will come under the purview, like against whom these fundamental rights will be applicable. So, Dr. Ambedkar, now who was the chairperson, he basically emphasized that the legislature is not just here to just provide fundamental right, but also, and rather more importantly, to safeguard them. So even what is the role of legislature is something which was emphasized by Dr. Ambedkar, and he said that what is the like what was the concern at that moment which he basically raised, that is how the legislature is going to safeguard these fundamental rights. Now what is the role of legislature? Legislature is the lawmaking body. So whatever laws the legislature is going to make, it should not affect the fundamental rights of the citizen. Now, the next portion also related to the debate, and as I've told you that the major debate was regarding the justiciability of the right or the non-justiciability of the right. And at that moment, also, Dr. Ambedkar said that these rights should be non justiciable because at that moment the state lacked resources. But ultimately, we have what we have incorporated in our constitution, that is, we have fundamental rights that are justiciable in nature. And as you can see, the discussions were conducted regarding the economic equality, regarding the personal law reforms, regarding the discrimination in public employment, which we used to read under Article 16 of the Constitution. So 16 basically talk about the equality in status and opportunity, and likewise equal rights for women. So for that also we have not what is given under the present document, that is the final draft which we used to read, that is the article 15 clause 3 of the constitution, which says that the special laws can be enacted for women. So here you can see the foresighted approach of our constitution makers, and they want to include each and every strata of people. And therefore it has been said that this is the document for the people. This is the document which has been made for the citizen of our country, for the people of our country. It was not something we are going to impose, but we are here to provide them with basic freedoms. Now, the next thing, as I am going to discuss about the area of cyberspace, and here just mention a brief about that what was the approach of constituent assembly maker and especially Dr. Ambedkar regarding the freedom of speech and expression. And he said that this is something which is a bedrock, or you can say the backbone of the democracy, and it is essential for the citizens to form their opinion, and that was majorly related to, he has basically emphasized it upon the vote, and they can use their vote properly, they can express, that is also a way of expression. And he also said that this freedom of speech and expression must not be absolute. Now, with the passage of time, what we can see, we have taken this freedom of speech and expression also from the Constitution of USA. And in this freedom of speech and expression, which we used to read now, right now, that is Article 19, Clause 1, it basically talks about the speech and expression without explicitly mentioning the freedom of press. But by the role of our judiciary, what happened actually, that judiciary included freedom of press also in our constitution, which was the part of which was something which was directly given under the Constitution of USA. Now, now I've come to the Constituent Assembly debate in context to Article 21. Why? Because we are going to discuss about right to privacy, and right to privacy is something which is given under right to life, personal liberty. Now, as it is given, is a one line article that is under Article 21 that no one should be deprived from his life or personal liberty except according to the procedure established by law. So earlier it was Article 15 of the Constitution, and the entire debate for Article 21 was majorly in context to the due process, and that was the American model. And here I've mentioned the people who are opposing this part of due process, the person or the people of Constituent Assembly who are in the favor of this due process thing. And okay. So here, as it is mentioned, that KT Shah and HF Kamal, they supported due process, and they but why? Because they were of the view to protect the personal liberty more strongly. But Krishna Swami Iyer and K. M. Munshi, they basically discussed about that why there was a debate regarding this due process, because they said that now everything will be in the hands somewhere in the hands of the judiciary, and that is something which is going to create problem in future, and that will going to create lot of dilemma in the mind of the people that what judiciary is going to do next. And this actually happened also. As soon as the judiciary expanded the horizons of Article 21 of the Constitution by the case of Maneka Gandhi, Article 21 include each and every aspect that is related to right to life. Okay. So you can understand the disagreement which was shown at that time regarding the opposition or opposing this idea of due process. And it has been said, as it is mentioned also, that there will be excessive interference by the court, excessive interference by the judiciary. And the government, that is the role of government will be restricted, and the power of the court will be increased. Now, again, it has been said that, however, Dr. Ambedkar believed that that is the although right to privacy was not explicitly included under Article 21, but at that moment, what was said that right of people to be secure in their persons, house, papers, and effects against unreasonable searches and seizures shall not be violated. So you can understand the importance of this specific line. Although the due process term was not been included, but unreasonable searches and seizures should not be done. That is, if certain activities are to be done regarding the seizure or regarding these searches, that should be in a very meticulous manner. That should be also in accordance with the law. And here, the role of Qazi Saeed Kamruddin is very important, where he asked for the amendment to protect against unreasonable search and seizure, similar to the American and the Irish Constitution. So, again, this portion of Article 21 is something which you have like discussions were done, taking in consonance the Constitution of America. And here Qazi Sayyid Kamruddin basically said that there's a need of an amendment to protect against unreasonable search and seizures, similar as it is given under the American and the Irish Constitution, and the secrecy of the correspondence has also been discussed. However, dissenting opinion were given by Sir B. N. Roy and Rao and K. M. Panikar. Now, secrecy of correspondence, if you connect it with the present scenario, the issue of phone tapping, that is again time and now the court used to say that phone tapping is something which is against the right to privacy, that is against the philosophy of Article 21, that is privacy that is given under the umbrella of right to life. So on 30th, and when he suggested the amendment, after that also twice the discussion were done regarding the privacy of the correspondence. and one in the year 1947, where the proposal was made to, where they have mentioned about right to privacy of correspondence as a fundamental right. And then in 1948, where again Qazi Said Kamruddin made the proposal that the right of people to be scissor in their person houses scissor should not be violated, and no warrant shall be issued upon probable cause. So just on the probable cause, the warrants or the scissors or the privacy of the individual must not be affected. So this is something he took the references from the American, German, and the Irish Constitution. And here come the legal part, what we used to discuss today, what I'll emphasize today. That is the role of judiciary in context to right to privacy, and the journey starts from the case of MP Sharma, where it has been said that the power of search and seizure held that privacy cannot be brought under fundamental right. And later on, the case of Kharak Singh, where the surveillance, undue surveillance, it has been said that this regulation whether infringes fundamental right or not. It has been said again that right to privacy is not a fundamental right. The judgments were given by the two judge bench and then the six judge bench, and then I'll show you that how the entire history of this right to privacy changed later on. However, the case of Maneka Gandhi is a turning point in the history of right to privacy, and as I've already told you that the judgment in the Maneka Gandhi's case bordered, or they have just widened the interpretation of right to life, and it has opened the avenue for the inclusion of right to privacy also. Now this privacy that we are discussing in this phase, that was in the, we can say, more in the physical sense, that was more in the sense of the criminal justice administration. And the privacy which we'll discuss later on, that I'll show you, that is in the digital era, that is in the contemporary era. So the case of R Rajgopala versus state of Tamil Nadu, where again the Supreme Court held that right to privacy has been implicit in right to life and liberty, that is guaranteed under Article 21. Similarly, PUCL versus the Union of India. This is again something right to communication. Now, this is something. This case has just left a vacuum, left a space, where they have said that right to privacy to communication depend upon the facts of the case. That is, if there is a requirement to do surveillance or to tap the communication just for the sake of the security of the state, then it is something which depends on from case to case. That is, we can say it is not something which is absolute. That is, right to privacy, we can say it is not something which is absolute. Now next comes the case of Selvi that came in the year 2012. Now the case of Selvi was related to the self incrimination. And in this case, it has been asked now that there the distinction has been made between the physical privacy and the mental privacy. And this case was something which is related to the different tests which can be conducted on the suspect, which can be conducted on the accused just for the sake of getting the information. And in this case, it has been said that if unnecessary these tests are being conducted, then this is something which is the violation of the mental privacy of an individual and also the violation of its basic human right. This is one of the case where the concern was shown regarding the unnecessary use of these techniques, that is the narcoanalysis, that is the polygraphic test, that is the brain mapping test. And therefore it has been said like it is something which is a kind of an harassment on the accused, even though we can get certain positive result. But if every now and then we are going to use this technique just for the sake of getting the information, then it is something which is uh, the against the right of self-incrimination. That is, no one can be a witness in its own case. That is given under Article 20, Clause 3 of the Constitution. Now, next come the right to privacy in the digital era. And there's a case of Unique Identification Authority of India and other versus Central Bureau of Investigation, where the Supreme Court had said that compulsory requirement of Aadhaar is not something which is mandatory, and the information must not be shared without consent, without written consent from the third party. So here comes the most important judgment that is related to the unique identification scheme and right to privacy in the digital scenario. The case of Justice K.S. Puttaswamy and versus Union of India. The judgment was delivered on 24th of August 2017, where a larger bench, that is the bench of 9 judges, as I've earlier told you that in the initial judgment there was a 2 judge bench, 6 judge bench. So this was a larger bench, and it has been said directly in this case that right to privacy is something which is intrinsic in right to life and personal liberty, and this is a part of a freedom which is given under part 3rd of the constitution. And now it is very clear from this judgment that the sharing of the information of Aadhaar or the whatever the online document you are uploading or sharing, that is something which is related to your privacy, and the control of such data must not be given to the third party. Now, here you can say the threefold test has been given in the case of Kuttuswamy, and it has been said that whatever data has been taken, it should be used for a legitimate purpose. It should be taken only when it is necessary, and it should be done like whatever data the government is taking, there should be certain restrictions on it. Okay, so if the aim is not legitimate, then the data should not be collected by the government. Okay. Now, what was the impact of the judgment? So there was a committee which was set up, and this committee actually drafted the law, that is the data protection laws, and ultimately the data protection bill came into existence. Now, what were the laws and policies in India in context to data protection? So, as we know, we have the Information Technology Act of year 2000, which was again being created on the UNICITRAL model, that is the international model related to trade. And the objective of this IT law, IT Act, was mainly to work in the area of e-commerce and to make e-commerce more smooth. Okay, sorry. And then amendments were being done. The major amendment were done in the year 2008, where 43A, 66E, 72A, these sections were being added, where it has been said that if the sensitive information has been leaked, if the sensitive information has not been protected properly, so in such situation the compensation will be given. Who will give the compensation? The company, or the authority who has given you, taken your data, and it has misused your data. Then comes 66E, which basically deals with the punishment for what? For uh, like publication of certain images, that is again going to violate your right to privacy. And then comes 72 and 72A, that is for the penalty for the breach of confidential data. That is, if there is certain sensitive information, then it should not be disclosed. And if it has been done, so for that, penalty will be imposed. Now, here comes the law or the privacy law of our country. That is the Digital Personal Data Protection Act 2023. That is the DPDP Act, which came in the year 2023 and it has received its assent on 12th August 2023. And this is the new data protection law of the India. And that is to protect the privacy of the individual, and the organizations who are managing the personal data of the viewers, they own the responsibility that how they are going to use that data. So this is again one of the major law of our country, where we can say the organizers were under the you can say they were going to manage the data in such a way so that it cannot be misused. And if something happens, so for that penalties will be imposed, and heavy penalties will be imposed. And this act basically talks about the imposition of the penalty, that is the highest penalties of 250 crore. Now, this digital uh, personal data protection act is based on the GBDR, that is the general data protection rules of 2018 that were applicable in Europe. So European countries were following the GPDR, that is the General Data Protection Regulation, that came in the year 2018. And after that, our country also started drafting our document that was related to data privacy and protection on the foundation, or by taking certain kind of help, or by taking by including certain kind of provisions or the portions from that GPDR. So you can see that what was the core area, or what was the salient features of this act. That is, this DPDP Act basically talks about the establishment of data protection board, somehow to enforce the privacy law, and to provide rights to the individual regarding the personal data. After that, in 2025, and very recently, that is on 14th of November 2025, the DPDP rules were notified. That is, we have this act in 2023. The entire act was not enforceable that moment, but as soon as the DPDP rules were being implemented nationwide, it made that act effective. So what happened? This the third portion, which says that these rules give full effect to the Digital Personal Data Protection Act of 2023, and they were being implemented on 14th of November. Now, what were given in these rules? So, data is something which is, we can say, as a kind of a fuel nowadays. That is the information, every kind of information, whatever you are going to share in the cyberspace, either it is on your social media or it is on your official, like professional accounts, either by the way of the mail, either by the way of the information which you are sharing with your company or organization where you are working, or even the university where you are studying. So it was given basically in the DPDP rule that the relation has been discussed about two parties. That is, the someone who owns the data and someone who is storing the data. That is the data principal and the data fiduciary. The imposition of rules have been done majorly on data fiduciary, someone who is going to store your data. And data principle have certain rights that they can give consent, or they can refuse to give consent to use their data. So this is the one of the major portion that deals with the informed consent. So if you are using my data, I'll be informed about it, and I can refuse to share my data. If I want to remove my data from your site, then it can also be done, and for that also the rules have been given. And like as a data principal, I have a right to know how my data will be used. And the third portion, which says about the special protection for persons with disability, that is, in these DPDP rules, if there is a child, if there is a person who is not able to manage his online information, or so let's suppose a social media account also, so special provisions have been given. That is, their guardian, or if someone who is legally been nominated for handling their account, for handling their data, they will work for, or even if that person has been appointed by the court also. So as it is mentioned that parental consent is required for the verification for those who are under 18 years. Then regular data protection impact, that is the assessment must be done. For what? For whom? For the data fiduciary, SDF, that is, who is having the sensitive data. Sensitive data fiduciary. Sensitive data, such information which should not be disclosed very easily. Something which is not a general information, which is a very sensitive information which should not be disclosed now and then. Then mandatory reporting to the data protection board. Now these there were certain challenges regarding the applicability of these rules also that I'll discuss later. So what else has been given? That, as I've told you, that if I want to remove my data, so that data has to be removed by the data fiduciary. And the data fiduciary, if it has been witnessed by the data fiduciary that something has not been like used, or like suppose there is certain accounts which are not being used for a time of 3 years, or there is an inactivity. So by giving a notice, they can remove the data. Now this is known as the erasure. The topic, that is, the erasure thing is given. So that is, the data can be erased. Then the processing of personal data that is necessary for research. Now this portion deals with the exemption. Now these were the basic rules And under these rules, basically, they have given that the government can use the personal data, but the criteria has been set that on what ground these personal data can be used. After that, now I have come to the major portion, that is what were the issues and challenges. So first thing is that heavy compliance burden on small businesses. That is to collect the data, then to manage the data, then to handle the data. We need cyber security, very good cyber security platforms from where the data should not be leaked. And obviously, if I'm going to use a very effective cybersecurity, suppose software or something like that, we need money for that. So SMEs, that is the small and the moderate enterprises, they will struggle regarding the consent management system. Like who wants to remove the data, who is willing to just do not want the data has to be stored in on their platform. So for that, they need human resources also, I can say, as well as the you can say the software portions also, where the data must be secure. Second thing, third point is multilingual simple accessible consent notices. Now when you read the DPDP rules, they have mentioned that whatever notices are being given, notices in the form what, like when you open a page, in the at the bottom of the page it has been given that this is the agreement, whether you are agreeing with it or not. So now under the DPDP rules, it has been said you are not just going to leave that column blank. The data fiduciary has to mention, yeah, whosoever has, they have to mention that for what reason you are going to take the data and you are going to utilize the data. Only after reading that, if the data principal is willing to share your data, then only it is something he is giving his consent. So for that, what is required, like more or less we used to see the notices in English that I have witnessed. So what is given, that whatever notices are being given, that is the consent notices, that should be in a multilingual languages, and for that also the human resources required, or you can say the use of technology is required. Again, the cross-border data transfer uncertainty, that is blacklisted. Now under the rules, it has been given that there were certain areas where the transfer of data should not be done. Now this is again on the discretion of the government, so that where the data should be transferred or where should not be transferred. Next comes the age verification accuracy. Now we have mentioned in the rules that someone who is below the age of 18 years, their for their account the consent of parents has been taken. The issue comes regarding the age verification. That is whether they are of 18 years or not, whether they are below 18 years or not. So what will be the criteria, what will be the parameter to verify the age? Then the other issues, that as I have told you that we have made our DPDP Act or the rules on the basis of GPTR, that is the general data protection rule. Now we have to amalgamate those rules with the DPDP rules, and it is something which is more complex and costly. Reason being that is Europe, and they have made their security system much effective. And when I talk about security system, it means the use of technology, and the technology which is more competent, more efficient, more workable, and such technology from where the breach of data cannot be done. So for again for that also we need money, we need infrastructure, we need institutional infrastructure. So this is again one of the issue. Then as it is when in the next point, that is lack of infrastructure in organization regarding immediate breach reporting. So if there is a small organization or if there is a medium organization, they lack infrastructure. This is something which is very pertinent in the Indian scenario. And then the third point, that is digital awareness, or you can say public awareness and digital literacy. This is again one of the area on which the government has to work. Now, what are the solutions for it? That is the data protection boards that are has to be constituted as per the act and the rules. They should be transparency. They should work in an independent manner. Next, the portion of digital awareness, capacity building, which means we need experts in the field of the uh, privacy of data. someone who has the knowledge regarding that how the data has to be secured. So here again, exchange programs has to be conducted by the government in context to the sharing of information. Now, what is capacity with that? Where the information has been shared. And in the cyberspace, what kind of information can be shared regarding the new technology, or how we can create our new technology, how the new technology is going to benefit the masses in general. Next, the infrastructure issues, as we have already discussed. And these DBDB rules must align with the rules of RBI. Now, RBI is also the Reserve Bank of India. That is again related to the portion of e-governance, we can say. So these rules must align to RBI and the global standards of GPTR. Now we have not opted all these standards of GPTR. We had opted some portion. Everything we have not even we're not in the capacity also, we can say, because we need very good uh, monetary portion. And the money is something which is very important with the use of technology. So this is all about the issue of privacy in the contemporary India, modern India. And when we have discussed it from the making of the constitution, from the Constituent Assembly, so we can say that our constitution is a social document and it works on the demands, need and demand of the society. And the transformation of right to privacy we can see from the making of our constitution, where we have discussed that undue searches, undue seizures must not be done. And later on, that physical privacy has been changed into mental privacy. That is in the case of Selvi. And later on, this privacy is now we can see in the cyberspace. That is in the on the online platform. That is on the by the way whatever information we are sharing. And so, even though the judiciary has expanded the horizons of Article 21 of the Constitution by including right to privacy as a portion of right to life, but the challenges are ever emerging. As it has been said, that law is not static; it is a very dynamic field. So, even if we have the law right now, we have DPDP rules, everything we have, but again, the laws are something which we need a robust structure, robust laws, which should protect our data. So data is a kind of a new fuel that is, as fuel we used to say, something from which we can drive our vehicles. So here fuel data is something which is a fuel for gaining the information. And here we can understand the role of AI, the artificial intelligence, that the AI has the ability to understand what actually we want to view. And till now we do not have any specific mechanism from where we can regulate that AI also. Like now and then, every now and then we read in newspapers that with the help of AI, the like we do not need doctors also in near future. The AI will perform everything. Who will own the responsibility if that robot or the AI has committed some wrong? And the rules related to AI, that is the laws related to AI, something which is a very like, wide stream, wide area. So on one hand, we are talking about the rules for the privacy, rules related to the non-sharing of the information. But on the other hand, this field of we can say technology is ever growing, and with that growth, the area of artificial intelligence also. So with this, I end my words here. Um,
Thank you so much, ma'am. It was a privilege to hear you after so long time.
Thank you so much.
Ma'am, your words reminded me those wonderful sessions in the classroom, and your presence just cherished the memories in my graduate journey. So, thank you so much for sharing your knowledge, experience, and valuable perspectives on data protection and evolution of fundamental rights. Thank you so much, ma'am.
Thank you so much, Manas, for inviting me. Thank you so much, this Vidhigyata protocol, Ashutosh, everyone who has been included, who has worked hard for making this portal work and inviting me for giving the lecture on this issue. I hope somehow I have helped you people to understand the legal background related to the right to privacy. Even though I tried to discuss everything, but some portions are also left now. Like I have discussed about the question of AI. So for AI right now, we need something very concrete so that the leak or the data which are using must be protected. So I'm thankful to the participants for having with me for a long time. It's beyond 1 hour, I think.
Ma'am,
So thank
ma'am,
you so much,
ma'am,
Mani,
this is a
Payal,
formal
everyone.
vote of thanks from Payal
Okay,
and the
okay.
team within. That was from my side. Thank you so much, ma'am, for accepting
Thank you,
being
thank
with me.
you. Thank you,
Thank you,
Manas.
ma'am.
Thank you.
Thank you very much, Dr. Mishra, for your insightful session. Your explanation on the development of fundamental
Uh,
Payal, you are not audible, I think.
While you are muted, I think.
To formally conclude the webinar, I would now like to hand over the session to Ashutosh Pathak, the founder of VIDHIGYATA, a law enthusiast from Jamshedpur and pursuing BA LLB from the Dr. Hari Singh Gaur Vishwavidyalaya, Madhya Pradesh, passionate about making legal knowledge accessible to all. Now the session is over to you, Ashutosh.
Thank you, Payal. Good evening, everyone. On behalf of the entire Vidhigyata team, I extend my heartfelt gratitude to all of you for joining us for this Constitution Day special webinar on evolution of fundamental rights and relevance of data protection and privacy in modern India, issues and challenges. First and foremost, I express our sincere thanks to our esteemed guests, Dr. Shasya Mishra, Assistant Professor and Domain Expert in Cyber Law, Uttar Pradesh State Institute of Forensic Science, Lucknow. Ma'am, your insights today truly help us understand how our fundamental rights have evolved and why data protection and privacy are now at the very core of modern constitutional discourse. Your clarity, examples, and balanced perspectives made a complex topic feel accessible and deeply relevant. We are genuinely grateful for your time and your valuable contribution. I also extend my appreciation to all the participants who joined us this evening. Your presence, your engagement, and your willingness to learn are what keep us motivated to bring such session to you regularly. As we celebrate Constitution Day, let us carry forward the spirit of awareness, responsibility, and continuous learning. We hope this session added value to your understanding and we look forward to hosting you again in the future events. Thank you once again for being a part of this webinar. Have a great evening ahead. Thank you so much. Thank you, Payal. Thank you, ma'am. Thank you, Manat sir.
So welcome, Ashutosh. Okay.
Thank you, ma'am.
So
Um, Ma'am, am I audible?
yes,
Yes, ma'am.
Ask you one question if
yes, Neha.
it's Khushi Joshi here.
Okay.
Hello, ma'am. I'm Khushi Joshi from Madhya Pradesh. Ma'am, my question is like in a country like India where digital literacy is still low, we know that, and how can we ensure that people truly understand the consent before sharing their personal data and not just clicking I agree and just I agree with the terms and privacy policies without knowing the consequence. So, what we can do?
See, that was a major issue. Therefore, I have mentioned in the challenges also that we need digital literacy. And until unless someone has come under the purview of that cyber fraud, cyber crime, till then nobody reads the consent. What is written, what is given under the cookies, what is written under the consent form, nobody reads. So for that also, we need, like, government must create certain kind of like platform for generating awareness. But with that, something that is my thinking, that if you are willingly giving that consent, that is that you are willing, we are giving the consent, that is you are willingly providing the consent to use your data. So if that data is misused, in that situation, as this is my opinion, that then person should not claim that crime has